parties, thank you for your statements today. I appreciate the statements of everyone who spoke. Obviously, feelings are very strong here. The victim's family has suffered a terrible loss, and Mr. Mosby is facing some very significant consequences for his actions. So, with any sentencing, we start with admonitions. These are parts of the sentence that are required by law. And Mr. Mosby, first, with these felony convictions, you may not possess a firearm at any time in the future. Section 941.29 of the statutes makes it another felony for anyone who has been convicted of a felony to ever possess a firearm, carrying with it its own 10-year period of imprisonment or $25,000 fine or both. Also, you cannot vote in any election until your civil rights are restored, and you are required to provide a DNA sample to the state crime lab and pay a DNA surcharge for each of these 4 counts. You are advised that if this conviction is reversed, set aside, or vacated, you may qualify to have that DNA sample data expunged if you meet other conditions under statute. Now, because the nature of the charges here, also you may not possess body armor at any time in the future. Section 941.291 of the statutes makes it another felony for anyone who has been convicted of counts 1 and 2 to ever possess body armor, carrying with it its own 15-year period of imprisonment or $50,000 fine or both. So in determining a sentence, the court looks at certain factors, and these are determined by our state law. They are also addressed by the parties in their sentencing memoranda and in the pre-sentence investigation. We start with the gravity of the offense. And here, this offense is almost at the highest possible level. The only higher level offense would be an intentional homicide. And here, this was not intentional. And I think everyone agrees, Mr. Mosley, that you did not set out that day to kill someone, including Ms. Mogensen or her child. But that was the natural effect of your actions. And you did take her life. You took the life of her child as well. And her family is now serving a life sentence of never having her or her child in their lives. And that's why this is a Class B felony. The only higher level is a Class A felony. Again, that would be an intentional homicide. But if you take someone's life in circumstances that for this type of offense indicate an utter disregard for human life, that's what puts you in the position you're in today, which is facing a very significant sentence. It's not in this court's capacity to weigh the value of a human life. Unfortunately, that's the only way the court can enforce the law, is to come up with a number. And frankly, it's disrespectful to Mrs. Mogensen and her child to assign a number to the value of her life and the value that it had to this community. But that's the only role the court can play. Nothing I say or order today is going to make this case any easier for anyone. It is only going to bring an end to the legal proceedings, at least here at the circuit court level. But that's why we're at the point we're at. You took 2 lives, and there are significant consequences that flow from that, from your decisions that you made that day. When I next look at your character and rehabilitative needs, now here, the only expressions of remorse I've heard from you were actually today. And even today, to be honest, in your statement, you've talked mainly about yourself. I heard very little about Erin or her child or the loss that her family has experienced. The letters from your loved ones are very persuasive, but what I have to focus on is your what appears to be a sort of beginnings of remorse and a very, what I would say, limited acceptance of responsibility, and then your rehabilitative needs. To describe this as an accident, I think, is accurate only in that, again, you did not intend to take a life that day. But that's not where the law ends. You chose to drive a car at an absurdly high rate of speed through the city, a very densely populated part of the city, through red lights, and you caused this terrible accident and took 2 lives. There is no question here that you bear the responsibility for those deaths. even if you didn't set out to take lives that day, it was the natural outcome of your actions. If you hadn't hit Mrs. Mogensen, you likely would have hit someone else. So when I look at your character, what I see is a young man who is just beginning to grasp the gravity of these offenses, which tells me you have very, very significant rehabilitative needs. I agree with your aunt that you probably need some mental health treatment, but that will have to be engaged in custody. That brings me to our last factor, which is the need to protect the public, and that is the number one sentencing objective. When we talk about how our state law defines sentencing, we start with protection of the community, and this is a case where you have shown yourself to be a real danger to this community. You have a limited criminal record, but your criminal record begins as a juvenile and continues through young adulthood right up to where we ended in November of last year with this terrible offense. You've been in custody since then. The fact that you were in contact with law enforcement on a regular basis and on probation, and that those probationary orders apparently were completely unsuccessful in redirecting your conduct, shows me again, very forcefully, that you have very, very significant rehabilitative needs. So when we talk about protection of the community, this community is absolutely outraged by cases of this type. It is not an exaggeration to say I've had a series of cases very much like yours, one after another, since I started in this rotation just over a year ago. And I've had so many, it's starting to get difficult for me to remember the facts of each case. Some stand out, yours stands out, because you took the life of a young woman who was about to become a mother. That is a tragedy of just almost incomprehensible gravity. Another case I can remember is a young woman about your age who took the lives of 5 members of her own family because she was driving recklessly at high speed through the city and crashed. I have another case, a young man, not much older than you, who took 2 lives in a crash and seriously injured other people in the same crash. Those are just the few I can remember off the top of my head, but there have been several others, unfortunately. And this community is absolutely outraged by these cases. I don't have an explanation for why reckless driving has grown so rapidly and so suddenly as a thing, but it is something people in this community have to deal with every day now. The city is installing speed bumps and traffic circles to try to slow cars down, and it is having some effect. But that's only on side streets. On the main roads, like the road you were on, that's a completely impractical solution. What we have to see is people slowing down. And that isn't going to happen until people who kill other people in crashes of this type go to prison. And hopefully that has a deterrent effect. And that is one of the objectives the court has to look at when I impose a sentence. We start with the protection of the community. Second, we look at your rehabilitation. Again, and your needs are extremely high. Last, we look at deterrence, how to deter you as well as others. And the court can only accomplish that deterrent effect by ordering significant sentences in cases of this type. So all of those factors and objectives taken together, and also the recommendations of the parties, the court comes up with what is the answer in this case. That is just an answer. It doesn't solve the problem. It doesn't even begin to solve the problem. And it certainly doesn't mean that this is the value of Ms. Mogensen's life or her child. But it will be the court's judgment in this case. So the court first, by law, has to consider probation, but it would clearly unduly depreciate the seriousness of these crimes if probation were granted. The court is ordering a state prison sentence here. The court is ordering restitution in the amount agreed to by the parties. That's in the amount of $12,599.81. The court is not imposing any fines because this is a significant prison sentence. The court does order you to pay all court costs, mandatory surcharges, and assessments. Those are the amounts required by state law. The court directs the DOC to collect any monetary amounts ordered today at a rate to be determined by the DOC from Mr. Mosley's prison funds. Any monetary amounts that remain unpaid when Mr. Mosley is released from confinement are to be paid as a condition of extended supervision. Any monetary amounts that remain unpaid when the sentence is completed are ordered reduced to a judgment against Mr. Mosley for any unpaid balance, and collection can then proceed as provided by statute. Because of the nature of these offenses under Chapter 940, Mr. Mosley, you are not eligible for early release programming, including the challenge incarceration program and the substance abuse program, and the court so finds. There is some credit for time served. Mr. Payne, what is that number?
Judge, I have 57 days, have not ran concurrent to his revocation, and have ran concurrent to revocation. We have 378 days.
Okay, thank you. All right. Regarding extended supervision, the court leaves those conditions to the discretion of the Department of Corrections. The court does though order a referral for mental health evaluation and also treatment as determined by the DOC. That is to be accomplished during the sentence. So with regard to the sentence, the court orders as follows. Now the PSI writer made a very significant recommendation. The state essentially adopted that recommendation with some changes. I agree that is the appropriate sentence here. And so the court is ordering as follows. As to count one, the court orders, this is consecutive to the current revocation, 20 years of initial confinement and 5 years of extended supervision. That is to be followed by count two, which is consecutive, 20 years of initial confinement and 5 years of extended supervision. Counts 3 and 4, which both also involve the death of Mrs. Mogensen. For counts 3 and 4, these counts are to be served concurrent with count 1. The court orders a total of 5 years of initial confinement and 5 years of extended supervision. That's on count 3. Concurrent with count 1. On count 4, the court orders 4 years of initial confinement and 4 years of extended supervision. Also concurrent with count 1, and those two counts relate to the death of Mrs. Mogensen. That is the court's sentence. Sir, the court is granting credit for 57 days time served, because again, this is consecutive to the current revocation. That would be applied to count 1. You have the right to appeal. Any notice of intent to pursue post-conviction relief must be filed with the clerk of this court within 20 days of sentencing. Your lawyer must continue to represent you until your decision to seek post-conviction relief or not is made. If you wish to seek that relief, your lawyer must file that notice within this 20-day time period. You receive a copy of this written explanation of the term sentence. Parties, anything else for the record? Mr. Lansky?
No.
Mr. Payne?
No, Judge.
All right. Now, I want to ask everyone to leave separately. I'm going to ask Mrs. Mogensen's family and supporters to leave first. Ask Mr. Mosley's family and supporters to remain. Mr. Mosley's family to remain just for another moment. We're going to keep everyone separate in the hallway.
The system's rigged, man, it's time to break free. Eyes wide open, gotta see what I see. Standing on the front lines, fighting for the truth. Lift the veil of lies, it's time to be the proof. Take a stand, don't you back down. Raise your voice, let's shake the